I don't give up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit.
If he thinks we can't do something, you're going to look at this judge and think I can't do something, young man. You're going to learn a big.
Court calls the case of the people versus Marquesi Hankey.
I'll let them be happy. People, Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan,
All right, it's your motion.
There's a good probably motion that was made to previous PCC hearing. My client's revoked from privileges from the jail, suspended due to allegations.
And here comes the detail that changes the entire argument. The tether is gone. The defense is asking the judge to trust that the defendant will follow stricter conditions, but the court is now looking at an existing condition that was allegedly violated. In a bond hearing, that matters a lot. The judge isn't just asking, can I give him another chance? The bigger question is, why should I believe the next set of conditions will be followed?
Contact with the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant with period in the jail. I also instructed my client that if allowed to be back on the bond, we would ask the court to hopefully to reinstate his original bond with tether. We know judge that he has no prior criminal, well, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this, but some of the language that was used in our conversations, I don't have phone conversations myself, but I will admit that it seems that my client had contact the complainant even after his bond. And so I say this, Judge, again, I know it seems...
That may be the most important statement from the judge so far. Notice the distinction. The court isn't saying people never deserve second chances. The problem is that this defendant allegedly had already been given conditions, and then, according to the court, continued violating them. A second chance becomes a much harder sell when the first chance is still being discussed.
Like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something, it means it. So I'm just asking, I guess, for some leniency to trust that Mr. Hankey will comply. He had a $75,000 cashier refund that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So just I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact them.
All right. Well, before I hear from the people, counsel, let me just say, you came in here.
Now, the prosecution brings out the evidence that makes this much more serious. Dozens of calls, multiple pins, and alleged continued contact despite restrictions. This isn't simply an argument over what the defendant says he'll do next. The prosecution is pointing to a pattern of conduct that they say happened after the court had already imposed restrictions. And that's exactly the kind of evidence a judge can consider when deciding whether additional conditions would actually work.
First time, and well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become...
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, And I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done, and then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to.
Okay, there's the courtroom version of "don't test the system." The judge is making one thing unmistakable. Incarceration doesn't mean the court loses control over what happens next. If the defendant believes restrictions can simply be bypassed, the judge is warning that the court has additional tools available. At this point, the issue isn't just the original allegations, it's whether the defendant respects the authority of the court.
Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't hook up what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you until I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continually, flagrantly calling the victim on other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns.
And that's the ruling. The judge acknowledges that mercy is available, but says it has to be earned. The bond reduction request is denied, and the existing revocation remains in place. After all the defense's promises and the prosecution's evidence, the judge ultimately decides that the documented conduct outweighs the request for another opportunity.
Especially given the violent nature of this case as well.
Anything else, counsel? I mean, counsel, does your client want me to just request to the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay. Right now? All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. You worried about my child. I can't say that I'm not in here for nothing. You obviously think I am. Yeah.
And notice the final procedural cleanup. The jail is now blocking the numbers associated with the alleged unauthorized contacts. So the court isn't simply ending the hearing with a ruling, the restrictions are being reinforced operationally as well. The case now moves toward the preliminary examination with the bond still revoked. One hearing, one very clear message. Court orders aren't suggestions.
I just want to apologize. Like I said, I'm not being bad. I don't want to be here. I really don't. Truly. So, again, please show mercy. Please.
I have no problem showing mercy to those that deserve it, and have earned it. You have not. Motion for bond reduction or any change is denied. This bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from what I understand, the PCC.
Yes, sir.
Move forward with the, other thing.
Is all discovery complete?
And I would ask if possible, what it's, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge
Harry.
Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday, and they have blocks full of victims, new numbers and old numbers, so there should not be any more
More calls coming through. All right. Thank you.
Thank you very much, Judge.
Thank you, Your Honor.